Hi friends, I hope you're doing well. Joshua Kappel here from Vicente, from Colorado for Ibogaine, from Healing Advocacy Fund, wanting to give you an update on House Bill 261325. If you've been following along on my Instagram, you've probably seen me posting updates about it. If you've been watching the news, you might have seen that it recently passed the Senate and the House. It was one of the last bills to pass this session, and now it's going to the governor's desk, to Governor Polis, who's been very supportive of this bill. I just want to provide a quick overview of what does this bill actually do. This bill started with this goal of how do we bring Ibogaine clinics to Colorado in an expeditious, safe, and culturally responsible manner. And the bill has taken a lot of different turns, especially because the state has no money. As I talk about this bill, there's provisions of the bill that are really contingent on finding state or federal grant dollars, philanthropic dollars, or general fund allocations in future years. The bill sets up a pilot program for Ibogaine research run by the Behavioral Health Administration. This pilot program costs $150,000, and so in order for it to go into effect, the state has to come up with $150,000 somewhere. Federal money, state money, private philanthropy. What the pilot program does is it tasks someone in the Behavioral Health Administration to choose up to 5 pilot sites and help them obtain federal approval to do research on Ibogaine. And this federal approval could be through an IND process. One of these pilot sites could be part of Texas's multi-state consortium. A pilot site could do their own IND. Potentially, a pilot site could be part of the Federal Right to Try Act if the latest executive order plays out and you can use Schedule I substances for the right to try, or any other federal law. There's a waiver under 872E where the U.S. Attorney General could waive certain provisions of the Controlled Substance Act. So part of the idea of the pilot sites is you have this person at BHA who is helping people obtain federal approval and also obtain other funding, gifts, grants, donations, other funding for their work. And so that is the pilot program that we set up. There's some specific requirements to be part of the pilot program. One is that if you're a pilot site, you do have to have a benefit sharing plan. The requirements for the benefit sharing plan for a pilot site are a little bit less onerous than they are in the full regulatory program that we'll get to. But for the pilot site, benefit sharing plan could be a financial benefit sharing, collaborative research data sharing with conservation support for plant species and habitats, community identified development programs, cultural or educational exchanges, or utilizing a source for Ibogaine that engages in benefit sharing and ethical and sustainable cultivation practices. And all these have to be with traditional communities that work with Iboga. There's a couple other, parts of the pilot program where BHA can work with tribal governments, other state governments, and really be part of the forefront of research. And we hope that, with this executive order that allocates $50 million to state federal research programs, that Colorado will be uniquely positioned to participate. Pilot program, run through BHA. We need $150,000 for it to go into effect. It's a federally approved program, so any sourcing also has to be federally approved. And you have to have a benefit sharing plan. And then the final piece, the bonus pilot site piece that's worth noting is if you are chosen as a pilot site, then you have priority application review if and when the state regulates Ibogaine healing centers. Some other pieces of that puzzle, there's some data collection, there's some protections around civil liability, there's protections around criminal liability. There's a lot of different pieces, where it's if you're, participating in the pilot program that's approved by BHA, you are exempt from state law, but part of the requirements is that you're also in compliance with federal law. So we'll see. Can BHA get some money from the federal government to launch this pilot program? If not, will someone else step up? Hopefully, will Colorado then be at the forefront of research around this? Yes. Is there a mandate for some benefit sharing programs? Yes. So the next thing is some cleanup to the Natural Medicine Health Act. One is, DOR said healing centers can't sell natural medicine to a participant for use in an administration session. Well, under this cleanup, DOR created a new license, the sales license, that allows a separate entity that's not a healing center to purchase, possess, transfer, and sell natural medicine to participants at a co-located healing center. And so this is really designed so people can compartmentalize tax liability under 280E. We'll see how much the fees are to see if it's cost prohibitive. If you're not separately invoicing natural medicine or not selling natural medicine, then this won't apply to you. And there will be, you will have to pay sales tax if you have one of these licenses, and you're filing sales tax. That is something you have to do. Another fix on the natural medicine health side relates to Ibogaine, and there's a couple of these. Generally, natural medicine cannot be synthetic. It cannot be synthetic Ibogaine. However, if and when Ibogaine is allowed at healing centers, Ibogaine can come from other plants, including Voacanga africana, or another source that is recommended by the Natural Medicine Advisory Board, and you can use a semi-synthetic process to isolate and bring forth the Ibogaine. So for future years, when we have Ibogaine healing centers, there'll be more options around sourcing, because that is a big issue that people have been trying to figure out. And to date, I don't know anyone that has figured out how to grow Iboga in Colorado, and also in an ethically or culturally sound way. Another piece that this bill does is it, allows DOR and DORA to make more rules around Ibogaine healing centers if and when they're permitted. So that includes medical pre-screening, EKGs, blood tests, genetic tests, or other tests that the state might believe, and really the community at large might believe is beneficial for the safe administration of Ibogaine, mandating continuous medical monitoring in certain circumstances, requiring appropriate oversights by trained and experienced medical professionals, requiring extended integration or aftercare. That's some of the changes. The extended integration aftercare specifically calls out that a healing center or facilitator can utilize referrals, medical and mental health professionals, and certified peer support specialists. Key piece. It's rid of the 5 license limit for having a financial interest in more than 5 business licenses at a time. And why this took place is because the state was taking months and months and months to approve healing center applications, because they wanted to vet every single owner or potential owner or anyone who was lending them money or who received any money, to make sure that no one had an interest in more than 5 businesses. And so removing this piece was actually a way to lower compliance costs, to lower licensing fee costs, to lower regulatory costs, to hopefully then allow DOR to lower fees, which could then hopefully lower costs for participants. And so that's where this all came from on the 5 natural medicine business license piece. I don't think we'll see, big interest come in. TBD, we can always advocate for it again if we think that's the case. In Oregon, we haven't seen anyone have more than 1 healing center. It's not like these are super profitable businesses at all. Another big piece of this bill is that it changes the advisory board in the future to allow for more people with experience with new natural medicines. We'll see what that looks like. The mandates that the board look at what plants contain Ibogaine in it and which ones are feasible for cultivation in Colorado and how to set that up. It also limits facilitators from civil malpractice, provided they're not deviating from generally accepted standards of care for facilitators, which you might be like, well, what does that mean? That is something that's still going to be figured out over the next 20 years, 30 years. As an industry operates, the industry collectively together creates generally accepted standards of practice. It's a huge piece, actually, to limit civil liability for facilitators, provided they're not acting outside of generally accepted standards of practice. And why this is so key is because it's very difficult for facilitators to obtain insurance that's actually meaningful. And so hopefully this will open that up. Now, this doesn't mean a facilitator does something clearly wrong or intentionally wrong or abuses power or breaks their ethical code that someone can't sue them. No. It's just if they're within those generally accepted standards of practice. There's some changes to section 18.434, which is the personal use section. So pull out your pen and paper, take some notes. What this section does, it clarifies that you can't sell natural medicine at a retail store, a vendor table, a vendor booth, or another commercial business. And the functional piece of what it says is, instead of being able to provide harm reductions at the time you're giving someone natural medicine, you have to provide harm reduction services when they consume it or when they're under the effects of it. And so the idea really is to protect that community-based healing. You need to protect the community healing circles. That was the intent of Prop 122. The intent was not to open up retail sales. And although I'm very supportive of retail sales one day. I'm part of the microdosing collective. We want safe access to certain products. That is not what the intent of Prop 122 was. And so this section in here clarifies that you cannot operate a retail sales business. You can't engage in disguised sales. So it's, for many people, this is no change in the law. And for some people who are pushing it, it clarifies that, like, hey, what you're doing was actually never intended by the law and is still not intended by the law. People who want to unpack what that means, what does it mean to provide bona fide harm reduction services? What does true community healing mean? Call us. It's a very, very nuanced section. There also is, for the healing centers, a temporary premise license where now healing centers can go to Beul. I don't know if Beul would want you to do it, but you can go out and have a temporary administration sessions. You can have groups of up to 64 people. You can go, out in nature and get a temporary premise, at particular spots. And the state still has to make rules about what that looks like. I think that, I think we'll have something that works, but we'll see. And you still can't have a temporary permit or an event. It's really like an event permit. You really can't have an event permit in a local jurisdiction that prohibits event permits in that spot. But hopefully, how it's drafted, in the end, you'll allow for event permits. We fixed some of the inspections, giving the state a little bit more flexibility so they don't have to mandate inspections all the time. Again, this is started this push of okay, we actually need to regulate natural medicine in the regulated side less because the regulations are very comprehensive. But in some cases, they're not needed. And so the idea is how do we walk that back a little bit? Again, walk back regulatory cost to then walk back licensing fees, to then walk back participant costs. More on the limited natural medicine sales license. The entities have to be co-located at the healing center. You have to have at least one person who owns the healing center and this other entity. And then there's some more rules around Ibogaine, what that looks like, different testing standards, different product limitations. There's also an interesting piece. There's only one testing lab in the state. And so if for some reason that testing lab ceases to exist, there's an amendment in here that allows DOR to allow people to use other labs. So it's kind of a fail-safe amendment in case there's no testing labs. So that's good. In an emergency, we have that. And so one of the big things that this bill does that I think is super important is that in the future, if and when there's Ibogaine healing centers, each of those Ibogaine healing centers has to have a benefit sharing plan. It has to be documented. And it says, a licensee seeking to cultivate, manufacture, test, dispense, or administer Ibogaine shall, in consultation with Indigenous communities or their authorized representatives, establish a benefit sharing plan that directly benefits those communities. A licensee may use or rely on a third party for consultation. And they have to document, this consultation process and the development of the benefit sharing plan. What could the benefit sharing plan mean? It could be financial benefit sharing, collaborative research or data sharing, conservation support for plant species and habitats, community identified developmental priorities, cultural or educational exchanges, or utilizing a source for Ibogaine that engages in benefit sharing and ethical and sustainable cultivation practices. And so this is huge. Huge, huge, huge. This is probably the only mandated benefit sharing plan in any US-based psychedelic law, especially one that mandates consultation. And so granted, the state of Colorado is not part of the Nagoya Protocol. Granted, there's probably still accusations that, moving forward with Ibogaine is extractive and exploitative in some way. Regardless, yeah, probably. And also, there has to be a benefit sharing plan. There has to be consultation. And so if you want to open up an Ibogaine healing center in the future, you got to get in the right relationship. Oh, this is the key piece too. And then so DOR also in here has the ability to issue cease and desist letters to unlawful businesses that are engaging in offering natural medicine services without a license. This is actually important because otherwise the enforcement is criminal. And if you're selling natural medicine without a license, as has been the law for a while, it's a Class 2 drug felony. It could also be you're publicly displaying natural medicine, which is a petty offense. Or you could be vending without a city permit. There's all sorts of things that already made this illegal. But now what this thing does is it gives tools to DOR to bring civil actions instead of criminal actions, so they don't have to encourage the local district attorneys to like charge people with felonies. They can say like, hey, stop doing that. And hopefully people will collaborate like, oh yeah, this is not what the intent of this law was. That's the final piece of the bill. Pretty historic. We're moving Ibogaine research forward. We're laying the groundwork for Ibogaine clinics. We're doing a bunch of technical cleanup to the Natural Medicine Health Act. Some of you will love it. Some of you will hate it. And if you have questions about it, feel free to contact us or me, or us at Vicente LLP. All right, take care, all.